earlier lecture, we talked about the philosophy of Indian Constitution, and we discussed the Constitution in the framework of democracy. We said that the Constitution emphasizes on not only the political democracy, but it also emphasizes on political, social, and economic democracy. So in the light of this consideration, we would be discussing a very fundamental part, central part of the Constitution of India, namely the fundamental rights. And I would be showing you that this fundamental rights has a unique place in strengthening the Indian democracy. So this is the objective of the lecture today. As I said that the philosophy, the broader philosophy of the Constitution of India, the framers of our Constitution, was extremely egalitarian. It had the aspect of equality, both the economic as well as social equality in mind, and hence the fundamental rights which are being framed also are in a way an evidence of the philosophy of the Constitution. So these fundamental rights which are included and guaranteed under the part 3 of our Constitution, they comprise of the articles 12 to 35. These are guaranteed in the sense that they are guaranteed by the Supreme Court of India. Means in case if the fundamental rights are violated, even if they are violated even by the government, one can approach the court under Article 32 of the Constitution. So this way they are enforceable. They are legally enforceable, unlike the directive principles of the Constitution. So fundamental rights, what are they and what do they convey, would be an interesting study, especially in the context of our discussion on political democracy, social democracy, and economic democracy. The fundamental rights, they were included in the Constitution because the Constitution makers, they thought that our unit would be an individual Indian, and the focus would be on preserving the dignity of the individual. Not only preserving the human dignity, but also developing the personality of every individual. It does not say one individual or other individual. Every individual was considered for, as long as he is a citizen of this country, be given the fundamental right. And they felt that the democracy is of no avail if the civil liberties like the freedom of speech, the freedom of religion were not recognized, and if they are not adequately protected by the state. So this was the broader framework under which the fundamental rights were written, and they aimed to strengthen the rights of the individual and hence the rights of the community, thereby strengthening democracy. Our rights to equality, as I said, the basic guiding principle is equality, and I had shown you both while discussing the directive principles as well as while discussing the broader philosophy of Constitution, that equality has a very important role in our Indian Constitution. So there are 3 articles which directly talk about the right to equality. They are Article 14, Article 15, and Article 16. So what does Article 14 say? Article 14, it guarantees the equality before law, and it ensures that each citizen gets an equal protection of the law, provided he or she is within the territory of India. Now that is very interesting. You must be aware of that in olden days, and as we read the olden texts, you might find that certain sets of people, they were given certain punishments based on their social status or the status because of the birth in a particular family. For example, if a person is born in a royal family, or in the so-called upper caste, he might be having a different set of laws to be uh, taken into consideration, while if a person belongs to the fringe group or a minority or a backward community, he might be having to face more stringent laws. So this kind of inequality was there earlier, but the constitution makers ensured that each one of us would be equal before the law, and irrespective of his position in the society, irrespective of his status, irrespective of his economical background or caste background. Okay. Now, of course, there are certain uh, liberties given to the rulers, and there are some exemptions, uh, especially for the ruling class. But that is exception, and generally speaking, Article 40 guarantees equality before law. Similarly, there is an equality against discrimination. So this is a negatively worded article, but what it says as a prohibition is in a way suggesting the right to equality. What does it prohibit? The article prohibits discrimination, and discrimination on the grounds of what? Discrimination, if somebody is discriminated because he is a Dalit or he's a Muslim or he's a Christian or whatever, okay, or suppose somebody is a woman and she is discriminated because she is a woman, okay, or somebody is from Uttar Pradesh and he is discriminated because he hails from Uttar Pradesh or he hails from Bihar. So this kind of discrimination is not allowed from the Article 15 perspective. Okay, so Article 15 prohibits discrimination on the grounds of religion, on race, caste, sex, place of birth, or any of them. So that is an important idea, and you know that especially in the changing times, we need such kind of articles in the Constitution which protects us on these grounds. Okay, we can approach the court if our right, if somebody is discriminating against us on these backgrounds. Okay, what does the Article 16 say? Article 16 guarantees the equality of opportunity in matters of public employment and prevents the state from discriminating against anyone in the matters of employment on the grounds of only religion or only of caste, only of race, only of sex, descent, place of birth, place of residence, etc. Now this, what does that mean? It means that historically the constitution makers knew that there is a bias against certain castes, and they have very less chances of being employed, especially in positions higher up in bureaucracy or in judiciary and all those things. So where the position matters, especially in public employment, there was there were chances of discrimination against the people of lower caste or of a different religion, not a majority religion, or even women. They faced this kind of discrimination because they were considered to be inferior and not competent and all those things. So such kind of discrimination now no longer would be tolerated by the Constitution. That is what the Article 16 says. So Article 14, 15 and 16, they in a way provide right to social equality. It's a very important right, and it tells us that all citizens are at par. Okay, and the earlier discrimination which existed are to be nullified. Now, does that mean that affirmative action will not be allowed? Somebody might say that, okay, so the discrimination is not allowed, so maybe there should be no reservations based on caste for the backward communities, like scheduled castes and scheduled tribes. But that is not what the Constitution makers had in mind. So what they said when they written, and they are written it very explicitly, that the state is not precluded from making special provisions for women and children or any socially and educationally backward classes of citizens, including the scheduled castes and scheduled tribes, because the philosophy has to be understood. It does not say that giving a positive or affirmative action is discriminatory. What it says is that historically, if there are certain groups which are facing discrimination and if it has to be nullified, then they need to be given adequate representation by a way of affirmative action, or as it is known as reservations, so that when they come to power in a representative manner, these biases would automatically go, right? So the affirmative action would be allowed irrespective of what the article of equality. If it is interpreted illogically, okay, then somebody might say that affirmative action is not allowed. But as I have explained, that is not the case. Similarly, uh, in public services, as I said, that there is provision for adequate representation of the backward classes. And that is because if you look at the data as to how many people of what caste are represented, you'll find that the communities which were historically backward, considered to be backward, especially the scheduled castes and scheduled tribes, they needed a separate kind of push so that they come into the public services, and then this overall administrative there's always an administrative bias. Okay, so this administrative bias would be nullified, and there would be more representation, and hence less chances of inequality. So this is a very important point which I wanted to make, that the Article 14, 15, and 16 and the affirmative actions, they are in a way complementary. What does Article 17 say? This is a very special article, and it has a very special reason for being in the article. You know that if you look at the freedom struggle, there were two sets of people. One set of people appealed to the higher ups in the society to give up untouchability, and there were other sets of people who used to make sure that this so-called untouchables were organized and they were made to fight with the against this untouchability. Okay, so both sets of leaders were represented by Mahatma Gandhi, who appealed to the consciousness, the people of the upper caste to give up untouchability, and there was Dr. Ambedkar and other leaders who rallied the backward caste and fought against this practice of untouchability. The special mention has to be made of Mahad Satyagraha, which Dr. Ambedkar led by he, along with his friends, he was a leader of that Satyagraha. We all often, when you talk about Satyagraha, what comes to our mind is the Satyagraha by Mahatma Gandhi. And yes, Mahatma Gandhi, he did lead us, and he did give us a very special weapon of Satyagraha against the British imperialism. But this another Satyagraha, which also is to be understood, the Satyagrahas led by Dr. Ambedkar, be it Satyagraha for allowing entry of the so-called untouchables in the temple at Karam Mandir, Nashik, or to make open the pond at Mahad for drinking water, especially for the untouchables, which they were not allowed to drink water in the Mahad pond. And that Mahad Satyagraha is also an interesting kind of historical struggle, which is found in the course of the 50 years where we had struggle against struggle for independence. Okay, so Article 70 abolishes the practice of untouchability, and that is the background. Both the struggles of Mahatma Gandhi and that of Dr. Ambedkar has to be kept in mind when we see this article in our constitution, which abolishes the practice of untouchability in any form, and it is made an offense punishable by law. It was further strengthened by Protection of Civil Rights Act 1955, and this too, that is the Rights Act as well as the Article 17, they go a long way in empowering us towards the social equality. So is the Article 18. The Article 18, which is the fundamental right article about social equality, It prohibits the state from conferring any titles other than military or academic distinctions to the citizens of India. It means that there was for earlier a tendency of the Britishers to honor certain individuals and give them certain titles like Lord and Sir and whatnot. Okay, so this was considered to be, when you are saying somebody is a Lord, somebody is Sir, like this, these titles, I am talking about title, then it was considered as against equality of status. Okay, for somebody might argue that what is wrong in that, and there are titles given even by the people, but people giving title to somebody and the state conferring title, they are slightly different. Okay, so Article 18 prohibited the state from conferring any titles other than military or academic distinctions, and the citizens of India were also not allowed to accept titles from a foreign state. So this was an important article, especially keeping in mind the social status kind of stuff. Indian aristocratic titles and titles of nobility, especially conferred by the British, have been abolished. So you understand that as we became a democracy, the fight was primarily against the Maharajas, the Nawabs of the erstwhile princely states, and they were considered to be superiors to others. Okay, by virtue of their being the Maharajas or Nawabs or princes. Okay, so this fight of the freedom fighters continued even post 1947, and one of this outcome was that the Indian aristocratic titles and the title of nobility were abolished. Okay, so this is a very important, though we now feel that why is it in the constitution, but if you consider that kind of struggle between the princes and the democratically elected leaders, one can understand why this article is in our constitution. This article 19 talks about 6 freedoms. Okay, and these 6 freedoms are very vital for strengthening the civil rights and making us the responsible citizens of India. So what kind of freedoms we have as a citizen of India? We have the freedom of speech and expression. We have the freedom to assemble, come together for a political reason, but without arms, obviously non-violent assembly of coming together. Freedom of association, freedom of movement throughout the territory. We can go to any part of India without any restriction. We can reside in any part of the country and settle also there in any part of the country, and we can practice any profession. Now this is interesting because you know that earlier there were caste-based professions, and now with the freedom and with the modern values, anybody who is skilled enough can practice a particular profession. So it is now only a matter of acquiring the skill to become that kind of professional. Okay, and it is not. It is now detached from the birth, whom you are born to, what your parents were. That hardly matters now when it comes to practicing any profession. Okay, so this is an important fundamental right. Nobody would say that, okay, you are a particular caste and why are you into this particular profession? Okay, so nobody can tell this because this would be against the constitution. So freedom to practice any profession. Similarly, nobody can say that why you have come from Uttar Pradesh and Bihar to our place and why are you working over here and residing over here. Go back to your place, okay, go back to your state. So that if somebody says and leads a movement, the Bhumiputra kind of Andolan, that again is against the constitution, against the fundamental right of the individual to work, to reside and settle in any part of the country of India. We can come together and voice our demands as citizens. We can speak in a fair manner within the constitutional limits against the government. Okay, and we can assemble without arms. So all these freedoms are vital if you want to strengthen civil rights. One of the important article which has been included in the 6 freedoms is the right to information. You know that this is a very important development especially because information is a tool which can lead us to empowerment. Okay, so this right to information has been included in the freedoms which have been guaranteed by the Article 19. So without these freedoms, we won't be able to uh, have an effective democracy. So that is a very vital 6 freedoms we need to cherish. There was another freedom which was called as freedom of property, which was removed by an amendment in the constitution, but we will take up that discussion in some other lecture. Okay. Uh, then there was a talk of liberty and protection against exploitation. Exploitation here is defined in a very narrow sense, but it is important. Okay. So what does this article say? The article says that, especially the article 23 says that it is one cannot have a human trafficking. Human trafficking means trafficking of the woman for prostitution, trafficking of children for child labor, etc. Okay, there are many issues still at hand, and the criminal code specifically prohibits human trafficking. So Article 23 prohibits human trafficking. It makes it an offense punishable by law, and also prohibits bonded labor or forced labor. It means that there were, and there even it does exist in some parts of India, especially the remote parts, where some people are bonded to the saukars, okay, money lenders, or large farmers, okay, especially because they might have taken some loans, or their parents might have taken some loan, and the loan agreement was that if the money is not paid back, then that fellow has to work without wages for so many years. This was called as a bonded labor. But Article 23 clearly prohibits such kind of forced labor or bonded labor, and now everybody is free to choose his master and work anywhere, okay, provided he's given the wages, right amount of wages. So this, though it is not, especially the bonded labor part is not very relevant now because of the activism, but this was an important agenda, especially when we talk about that era, 1950s. So nobody, even today, can go for bonded labor. Nobody can make anybody to work without wages. That is punishable. And nobody can employ the children below the ages of 14 years in factories. This is especially important because we do hear stories like children working in factories, the factories of making fireworks, the crackers business, okay, or there are children working in some hazardous kind of situations in factories. So this kind of, if you find that there are children working below the years of 14 years in some hazardous jobs, one can directly approach the constitution, one can directly approach the code and see to it that the employer is punished. Okay, so that is possible because we have Article 24. Who can be punished and what, under what law one can be punished? That also is framed in the constitution, especially in the articles 20, 21 and 22. So these articles 20, 21 and 22 are about personal liberty, right to life, and even the rights of accused. So that doesn't mean that a person is accused and is sent to jail, doesn't mean that he does not have certain rights. So our constitution does give some rights and liberties even to the accused, and which is very important. So all these articles from 20, 21, 22, 23 and 24, they can be grouped into the articles which strengthen the liberty and protection and gives us protection against exploitation. This is an interesting thing, especially in the context of democracy. We, interestingly, do not have any state religion. Of late, there is a debate as to whether the word secular, which was put into our preamble of the constitution by Indira Gandhi, the then prime minister, was the right thing to do. There is also a school of thought which considers that the present setup of the Indian Constitution, which has an emphasis on secularism, is not correct, and the state should have a particular religion. But if you read the constitutional debates and if you read the Constitution, our constitution makers, our freedom fighters had a very radical vision about the secularism. What is that? Uh, see, see the contest. It was a contest when there was another uh, country which was going to accept a state religion, Pakistan, and we were partitioned based on the religion. Okay, but interestingly, our freedom fighters like Jawaharlal Nehru, Mahatma Gandhi, Dr. Ambedkar, and so many of them, uh, Maulana Azad, okay, all this, they had a very radical vision about India, and they said that whatever happened, we are not going to be a Pakistan kind of framework. We are not a Hindu Pakistan. We are a progressive nation when we don't want any state religion. Okay, so this is a very progressive step, and look at that time, about 70 years ago, a country thinking on this lines, freedom fighters thinking on this line, and look at the way Pakistan has degenerated because of accepting a particular religion as a state religion. So we find that they really were visionaries. Our freedom fighters were visionaries by putting religion in its place. Religion was supposed to be a personal affair, and people in groups had the right to worship, but government would not be a part of the religion. That was very clear to our constitution makers. So what does Article 25 says? Article 25 guarantees the people to preach, practice, and propagate any religion. Okay. It does not guarantee to convert, but it does guarantee the people that they can preach any religion, they can practice any religion, they can propagate any religion of their choice. Okay, so that was guaranteed by Article 25, right? And Article 26 even guarantees the religious sects to manage their own affairs. They have their own ashrams, set up their own ashrams, own religious charitable groups under a charity commissioner, and buy properties and run their ashrams. Okay, so this is also perfectly legal as per our constitution. And Article 26 also allows all religious dominations and sects subject to the public order, morality, and health to manage their own affairs in the matters of religion, set up institutions of their own, right? And also fund the educational institutes. So there is a typo or error over here, but this is very interesting that government is secular. Government does not have a state religion, but government gives people the freedom to propagate the religion. Okay, and government clearly says that okay, if I am funding you as an educational institute, uh, you cannot impart religious instruction. So this way, this was in a way a compromise because there was a radical thought also, which wanted government not to encourage religion at all, not to allow the people to preach the religion, just to confine the religions at homes. But because it was a diverse group debating in the constitution, ultimately it was agreed that people, because they are religious minded people, and it would take time for the people to grow and become more secular in the real sense. More secular, you understand that secular is not the word related uh, to religion in that sense. Secular is a word independent of religion. When we talk about secular matters, we talk about the matters related to our health, matter related to our marriages, matter related to our acquiring property, all these issues which has nothing to do with liberation of the soul and all those. That is that is what is secular. Today, people understand secular in the terms of being um, anti or pro-Muslim. That is not how the word secular has its origin. Okay, so this is very important. I feel that this is an important issue that, along with the freedom of religion, the government didn't have its own state religion. Okay. Article 29 and 30 uh, uh, were framed especially to address to the concerns of minorities in the secular country. What were they? So there were Sikhs, there were Muslims, there were Buddhists. These people, these sects, they obviously might have actual grievances, real grievances about the culture of a dominant religion being imposed on them. Okay, so what does the Article 29 say? The Article 29 says that the state cannot impose culture on minorities. Okay, so this is an important protection given to the minority groups in India, and they were allowed to set up the minority educational institutions because they might feel that the education imparted by the majority educational institutes might impose their own cultural values. So this was to ensure that people 70 years back had the right to have our own culture, and because it was recognized that India is such a diverse country with so many different cultures, so many different languages, so many different groups. So liberty is at most important, and of course we need to grow and develop a feeling of funness and of being an Indian, but that does not mean that everybody should be uh, flattened and given a single culture, or everybody should be imposed upon a single cultural or educational kind of stuff. Okay, there is a debate as to the secularism in India and secularism in some other parts of Europe. If you look at the history of Europe, you'll find that secularism emerged because of the fight between the church and the state, that is the government. Okay, and gradually the state owned and the church were suppressed, and that became a basis of separating the church from the government. Okay, so the church were given a very restricted rule, and the government, there was no interference of the church in the government matters. So that is what is called as secularism in the European framework. In our framework, what we see as secularism is a sarva dharma sambhav, wherein all the people of all the religions are allowed to practice and propagate their religion. Okay, so that is what is secularism in our constitution. There is a school of thought, like a famous historian, Romila Thapar. She says that now we must grow up and we should ensure that the sphere of the religion should be confined. Okay, and we need to have laws even in the personal domain, wherein everybody has a progressive law. There are no laws of Kha Panchayats. There are no laws of Muslims or Sikhs or Hindus for that matter. There should be some uniform law even in the personality domain, and those laws should be framed as per the progressive values of strengthening the rights of the woman and irrespective of caste and religion. Okay, so this kind of discussion is happening in the academic domain. So what is important is that the fundamental rights which we were discussing, they do strengthen democracy. Okay, they do strengthen democracy by giving ample liberty to the individuals, by ensuring the rights of backward castes and communities, by incorporating into it the rights of minorities, and by assuring everybody, each citizen, impartiality in matters of justice. So I feel that these four things which are summarized as a contribution of fundamental rights, they do strengthen our political democracy, social democracy, and economic democracy. Thank you very much. Bye for now.